In a controversial ruling, the Allahabad High Court a few days back determined that grabbing an 11-year-old girl's breasts and breaking her pajama string did not constitute attempted rape. The justice classified the assault as aggravated sexual assault under the POCSO Act that protects children and Section 354B of the Indian Penal Code, sparking outrage among several people who argue that it undermines child protection laws. The decision has reignited debates over judicial thresholds for sexual offences against minors. Joining us now, the Honourable Dr. Justice Satish Chandra, former judge of the Allahabad High Court, N.S. Napinai, senior advocate of the Supreme Court, and Kapil Sankla, a lawyer in the Supreme Court. Thank you very much for being with us. Justice Chandra, let me come to you first. When we look at it from the prism of protecting victims, does classifying this assault as aggravated sexual assault rather than attempted rape understate, in your opinion, the severity of the crime and therefore potentially weakening the protective intent of the POCSO Act, particularly for children under a certain age?
Look, every case will have to be decided according to law, and in the particular circumstances, peculiar circumstances, or the facts of the case. In the instant case, this case cannot be decided emotionally, or you can say sensibility or public opinion or like this. It will be decided according to the law. Here in this case, the prosecutress is 11 years old. Both the boys are major, and they tried to catch the victim and to drag beneath the culvert this girl, and they also try unrob that girl. These are the charges. In these circumstances, the police has booked them under 376 of the IPC, that is the rape case. But let me tell you the pressure on the police who did it. 173 1A of the CRP is saying that in these cases, the investigation will have to be completed within 3 months by all means, where child abuse is there. So they did it. Now come to the point of this, what is rape, or in these circumstances, 375 is defining the rape and 376 is the punishment. And this is the rape definition. If you will go, you will find that sexual intercourse with the female in the circumstances against her will, without her consent. We are not concerned with this. There are 6 circumstances they have mentioned, 375, and last one is with or without her consent, because prosecutress is a minor. So it makes hardly any difference there was a consent or no consent. So this is there. But there is one explanation is given in this one, 375. The penetration is sufficient to constitute the sexual intercourse necessary to the offense of rape. It means that penetration is required.
From that standpoint, this particular judgment was made. N.S. Napinai, there's been considerable public criticism of this. In light of the criticism, I just wanted to go across for N.S. Napinai. I just wanted to go across to N.S. Napinai as well, sir.
Let me finish. Can I finish it?
Yeah, quickly, sir.
My submission. In the case of the Madan Lal versus Jammu Kashmir State, 1997 Supreme Court upholds that the attempt to commit the rape and rape both are the distinguished offenses. Okay. They cannot be clubbed together. These are quite different. And in this case, as I told you, that penetration is must for this purpose. 375 explanation is there. And Section 18 POCSO Act, they said that offense was committed. POCSO Act means protection of the children from sexual
Okay, Dr. Chandra, I get the points you're making. I wanted to get a reaction also from N.S. Napinai. In light of the criticism from legal experts, from the public, others, what implications might this order have for future judicial interpretations of the word attempt versus preparation in sexual offense cases involving minors? Because, it's these two words which, in a sense, got the judgment to where it was, what happened ultimately.
Vishnu, that's literally the crux of the issue here. We are not really going into the technicalities issue in this case. The simple case is that it is at a preliminary stage. It is still pending trial, and it is for the trial to set out what exactly happened. And it is only after evidence is taken on record that a decision can be made. It would be very trite for me to set out that in any of these crimes, there are 4 stages. Intention and preparation is the first stage, which is not a stage where you are prosecuted. Attempt and commission, that is where the prosecution happens. There is one line, Vishnu, that really sets out what amounts to attempt. When involuntary of one's volition, you're not able to complete a crime, then it is an attempt. In this case, it very clearly comes out that it was involuntary of the volition of the perpetrators that it stopped them from committing the crime of possibly rape. So at this juncture, when the case is at a premature stage of just framing of charges, I feel that, and it is my opinion here, I feel that it was not appropriate for a court to intervene at this stage to make a distinction to say it is only a preparatory stage and not an attempt. I think that is a absolutely fallacious conclusion. Secondly, the issue that you raised, it's not just about offences against minors, but it is for any woman or child. Imagine, when exactly are you supposed to assume that this is an attempt and only a preparation? When exactly do you exercise your right of self-defense? At every stage of a crime against a woman, this case is something that is going to impact our rights. And therefore, I definitely believe that this is indeed a fit case for the Supreme Court to intervene so moto, or I do hope that there is going to be an appeal by the state otherwise, because this law needs to be set right.
Kapil Sanklap, and just explain this to me and to our viewers, what specific evidence did the court find insufficient to prove that the accused's intent to commit penetrative sexual assault, given the physical acts of breaking the girl's pajama string and the attempted dragging, was insufficient? I mean, isn't that an act, tearing the pajama string, forcing her into that culvert, wasn't that intent enough, to show what they were trying to do?
So when I'm teaching law and I want to distinguish between, say, preparation and an attempt, how I teach is that imagine a person wants to pick a pocket. If his hand moves towards a person, or if he sits in the bus with the intent, that intention is there, he prepares for something, perhaps takes out a blade or something. But the moment the blade touches a person's pocket, that intention is very clear. If we go by that, which is the settled proposition of basic law is taught, then I really fail to understand, in my considered view and with all deference to my laws, why would they, when the pajama strings have been broken, the body parts have been touched, say that this was preparation and not an attempt? It fails the very touchstone of how basic law is taught in colleges. But having said that, you also have to understand the second part of it. With the advent of the new laws and the change in the perception in the Honorable Supreme Court and the courts, you are saying that we are not just bound by law, but we actually dispense justice. Here is an 11-year-old child. An act has been done. Imagine the large case ramifications if the laws are watered down as they have been watered down in the preliminary stage itself. Would it not mean that tomorrow a victim of a crime who perhaps is a minor would not go to the police station because it knows that the charges would be watered down? The police would be bound by a dangerous, if I may say so, again with all due respect, a dangerous precedent that has been set. Would it not be that this kind of judgment would have larger case ramifications as to what is rape? Because I am not in agreement with my lord when he says that only penetrative sex. There is also called digital sex. And the very definition of rape has also been increasing over the years with the advent of new and other things. We also know where there is an insertion or an attempt to insert something is also said to be an attempt to rape. So as far as the law is concerned, in my considered view, this should have come not under preparation, but at the intent, especially looking at the fact that this is a POCSO case. It is not a case where an attempt was made, a hand was taken toward the pajama, but the pajama was not touched. Here is a case where the nada itself was broken. And once that is done, I think there is a complete quietus as to what actually took place, what the intention was, and the preparation now takes a backseat.
Okay.
Now, so as far as the law is concerned, and I'm a defense lawyer, but in my considered view, in this case, at this stage, the court should not have watered down the offenses that had been put in, especially in the light of the fact that an act had already been committed. Now, after the act is committed, I don't think you should be watering down something, giving an interpretation that fails the very touchstone of what we have been taught in law schools, please.
Okay. Justice Chandra, I'll let you answer that question, but also my question to you is on judicial thresholds. And again, explain this to us. How did the Allahabad High Court, in your opinion, determine that grabbing an 11-year-old child's breasts and attempting to drag her beneath a culvert lacked the, quote, greater degree of determination, which is required to classify it as an attempt to rape under section 376 or 511 of the IPC?
Not 11. Don't be emotional in this matter. Come to the law. What explanation, which is the part of 375, the court has decided through that one. Penetration, they saw it. In this case, rape was not committed. Only attempt was made, and that is why they said 356, assault with intention to outrage the modesty of the female. 354B, assault or use of the criminal force with intention to disrobe the girl. So this is there. 9/10 of the POCSO Act, Protection of the Children from Sexual Offences Act, is saying the same things, that aggregated of the sexual assault. But when offense has not been committed, how you can say so? And in this case, the boys were not undressed. They tried to undress the girl.
Okay.
So all these circumstances will have to be lead. Otherwise, if we will frame the charges against the accused right now, I have no sympathy with the accused. If charges will be framed, it will be collapse in the trial, final trial. The whole case will go away. Even the attempt will go away. 354B will go away. Because you have prosecuted them under 376 and no offense is made out. So this will collapse the case of the state. And now this is a single judge view. You can go in the division bench if you are not satisfied.
All right. So there is a process of appeal absolutely over there. Look, NS Napina, I'm sorry. I'm just going to have to end it over here. We're completely out of time. I would have loved to have heard from you. But it's so wonderful to have a wonderful judge and two wonderful lawyers try and explain this to us on a case which has really shocked so many. Thank you very much for being with us. We'll take a short break. There's a lot more coming up on Left, Right and Center, including a very special interview done by my colleague Kanima Biswas. That's up next.